Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. More often than not, I have told you that speedy justice is a fundamental right. Article 21, right to life and liberty. So, a person should not languish in jail. A person should not languish jail for the sake of the so-called tardy trial or delayed trial. And you may be remember, Rudal Shah case, so many cases are there. Nilavati Behra, compensation, Rudal Shah, and Hussain Ara Khatun, very famous case. So after that, in Hussain Ara Khatun only, Supreme Court came to know that so many persons are languishing in jail without trial, even though they have completed the period of sentence. So after Hussain Ara Khatun's case, Supreme Court has clearly stated that if a person has completed 50% of a sentence, 50% of the maximum punishment, he should be enlarged on bail. But still, so many people are languishing in jail. Very recently, Honorable Supreme Court of India granted bail to 12 convicts who were languishing in jail for the past 14 years. You know, they were convicted for life. Life is almost, we think that it is 14 years as per section 31 CRPC. So now they were released on bail. Two judges, Indira Banerjee and A.S. Bopanna, while disposing the case of Rajendra Singh and others versus State of UP in WP number 52 by 2022 on 25th March 2022, enlarged 12 convicts are on bail as they were actually languishing in jail for the past 14 years. What is this? So where are we? Please remember how these things are happening. Definitely it will happen, because when once conviction is given, normally they will go for appeal. So appeal, do you think that the appeal will be decided within 1 or 2 years? It may take 4 years. So you will be, not already I told you, if you remember, a second appeal of 1996 judgment in Ongole కోర్టులో 1996లో వచ్చినటువంటి జడ్జిమెంట్ మీద సెకండ్ అపీల్ ఏపై హైకోర్టుకి వెళ్తే ఈ రోజు వరకు తేలలేదు. See, this is the ground reality, right? So now the persons have been convicted, they have been in jail for the past 14 years. So this is in fact more than the sentence awarded to them, but they were not released. And here important point, their appeals were not considered, their appeals were not disposed. This is the situation. So normally, as students, you may be under the impression that why these people are already having 14 years undergone, they might have been released. But the appeal is pending. So if the appeal is reversed, it may go to death sentence also. Therefore, definitely they have to wait. But speedy justice, my first words, they should be done to any person. It is his right. It is a human right. It is fundamental right as per Article 21 also. So here it is violated. Anyway, luckily these people have brought it to the notice of the Honorable Supreme Court of India. So please remember, these people, they have lost all hopes. They have lost all hopes of getting substantial justice from the High Court because the appeals were not disposed. The appeals have been pending. Of course, this corona pandemic, it has stalled the cases for 2 years, 2 years, no procedure, only virtual hearing, that too our virtual hearing law. Public interest bail petitions, regular trial that is not conducted. It was an impediment. Is it not? 2 years is not an easy time. Right? Of course, Supreme Court and High Courts are, even for that matter, even the Mufsil Courts also, they took initiative and they have at least done the work through virtual mode. Blue Jeans. You might remember. Don't forget Blue Jeans app. Right? So they lost all hopes of getting substantive justice from the High Court. So please remember, even if they are convicted, even if they are acquitted, so they had undergone more than the desired sentence, more than the declared sentence. So it is nothing but violation of Article 21. So, and also please remember, it also indirectly falls into the teeth of the judgment of the cases. So please remember the very famous Hussain Ara Khatun versus Nara versus State of Bihar. So in this case, only after this case only, the courts came to know that so many innocent persons, they have been languishing in jail. But anyway, Supreme Court came to the rescue of these people and released them on bail. Of course, subject to the result of the appeal. If the appeal says that they should be hanged to death, yes, once again they have to come back. Very good judgment. Please read it. Of course, I have been telling this type of judgments quite often. Right? This is one such. Thank you.